right, we are live. Welcome everybody to a Wednesday web chat. I am not going to MC this week because our friend Mike Finkelstein's going to take over, but I'm just so used to saying welcome from a rainy day in New Orleans.
Yeah, I shouldn't even let him go that far and just cut him off. I'm guest emceeing Michael Finkelstein here with Scott Sternberg, the man giving the interview. We've got our friend of the firm, Jeff Carell, joining from Nooner Tate in Lafayette. And so we are live on Facebook for the SNW Weekly Wednesday web chat. Today we're going to be talking election law, and I'm very excited that we get to have this fun dialogue between Scott and Jeff, who just recently launched a website. So Scott, why don't you start us off? I got to say, as we preface today, it's a fun time to talk about election law. We just had some elections in New Orleans and some other elections statewide, and we always have more coming up. So Scott, why don't you take this opportunity to tell us about a website that you just launched and this new project that you're launching?
Right, it's a never-ending cycle of elections in Louisiana. It's our favorite sport, right? And no matter what happens with COVID, we may not have football, but we will have elections in the fall, and we're excited to see qualifying starting next week. So Jeff Carell, my friend, my longtime friend in Lafayette, and our friends in Shreveport, Tom Arsenault and William Bradford, we've all kind of been doing election law for a couple of years separately. The people who do this kind of work, they're few and far between. And it's a really high-paced, fast-paced, and super interesting area of law. And so, you know, the three groups, we decided to get together and launch a website called LouisianaElectionLawyer.com. And basically, we're trying to get people who need help with their election problems. Maybe they have a defamatory flyer where they're trying to disqualify a candidate. And so we, all got together and basically, we've been sharing information and being friends and kind of swapping war stories. Jeff and I have been swapping war stories for years on these election cases. And we just decided to kind of make it a little more formal now. And so check out LouisianaElectionLawyer.com. It's a great resource and kind of tells you what we're doing. And, if you have a problem in SNW.LAW or in Acadiana, Jeff's your guy. If you're here in New Orleans, obviously our firm can help you out, but if you're in Baton Rouge, Jeff and I might do it together. You never know. And then we've got North Louisiana covered as well, the great North. So
the idea here is the network throughout the state, right?
Right. It's to cover the whole state, and we think that with the 6 lawyers that we have signed up currently, that, we're going to be able to handle pretty much anything that the elections throw at us.
All right. Well, let's go ahead and get started. We've got a bunch of topics here. This is a really dense topic, and so there's quite a bit to cover here. And so I wanted to start out with just kind of the basic idea of what are election challenges? Why are they important? What exactly is an election challenge?
Well, I guess I'll ask Jeff to give me a hand on this too. I mean, election challenges come in all shapes and sizes. When somebody qualifies for office, sometimes they don't necessarily hold the requirements of office. Like you have to live in your town for a year before you qualify for mayor, or you have to have 8 years of practice before you can be a judge. And so that's the primary thing that we see, in election challenges, right, Jeff?
Yeah, I mean, obviously from a qualification of residency, and then as you know, Scott, there's other qualifications through the Secretary of State's office and the election code for filing tax returns, extensions, etc. And it's unfortunate, but it is somewhat of a technicality. But candidates can also be challenged and knocked out. We've done that several times just on their failure to properly file tax returns for 5 years preceding their qualification.
Right, and after Katrina, they passed a law. That's what all this came from. After Katrina, they passed a law that said you had to file your tax returns in the state. And Mike, you and I have had a very famous victory on the tax return filing. Yeah. That went all the way to the Louisiana Supreme Court and got a Supreme Court justice reelected. But the tax return thing is a pretty basic thing. If you don't file your tax returns or you don't ask for an extension, you can't run for office in Louisiana, a state office. you can run for federal office, but you cannot run for state office.
Sure. So we've kind of, that touches obviously on filing tax returns. I think that Jeff, you kind of touched a little bit on residency requirement. What are some of the other areas that someone, might want to lodge a challenge against a candidate?
So another popular one, which is it almost comes up every year, is if an incumbent or someone who previously held office has any outstanding ethics fees or violations, and it's a really easy item to look for. You can go online on the database and check out the candidates, and so anyone who's running for office, if you want to run or if you're running, you should definitely look back on yourself and make sure there's no outstanding fines or violations. But for anyone running against you, you should do a background check as well. It's another very simple criteria to challenge someone running for office, and it applies to all elected officials, statewide officials.
And is that something that you'd find in the public record, Jeff? And if so, where do you find something like that?
So those can be found on the Louisiana Ethics Board website. You can look up each candidate and you can determine whether or not they have any outstanding violations or fees.
Right, and the Louisiana Department of Revenue has to tell you whether or not somebody's filed their taxes. That's a big thing for us. We request everybody's tax returns just to see if they filed them or not. But, sometimes a lot of this stuff is in the public record, like Jeff says, but sometimes when you're talking about like a residency or a domicile challenge, that kind of stuff's generally not in the public record, and it can be a difficult thing to prove.
Sure. So let's come back to the residency one, but can you tell us a little bit more about, if you think that a candidate hasn't filed their taxes, what are the steps that you take at that time? And, what's something that a member of the public can do to find out whether a candidate has filed their taxes?
Well, it's really easy. There's a public records request form on LDR's website. Jeff's got it right there. You just fill it out and you say, I want proof that Jeff Carell of Bill Platt filed his taxes. And they have to send you a statement as to whether or not Mr. Carell has filed his taxes for the last 5 years. And if he hasn't, he's disqualified.
Okay, and that is something you have to prove eventually.
Right.
And kind of getting away from the taxes and back to the residency, Scott, we had a case this past year that dealt with residency. Can you talk about residency requirements and what's required to run for a candidate, or how a candidate can be challenged for residency?
Right. So every parish is different, particularly for local offices. Like some cities require that you be a domiciliary. Others require that you be a resident. And there's a really big difference between those two. Jeff, you've tried a residency challenge, right?
I've tried a residency. We also tried an elector challenge. So there's also some local offices that require you to be an elector. So you even have to prove that you're a registered voter within the district in which you're running for. And so yeah, we've challenged all three of those. The residency case we tried was it took a long time to gather the evidence, and you have so much time in these cases. I hope you'll touch on that, Scott, how much fun it is to get a case together in 3 days.
Yeah.
But yeah, we have successfully disqualified candidates based on where they live. They've registered using either rental apartments that they use for commercial purposes or property that they own. I wish this was a joke, but it is true. We had one lady who registered at a barbecue stand. She used it as her address for purposes of running for office. We hired a private investigator. We had it photographed, confirmed it was not a house, and we had her excluded from running. So
that's right. And the problem is that you can have multiple residences, but you can only have one domicile, right? So you have a lot of people who have multiple homes. So maybe they have an apartment in the French Quarter and a house in Lafayette. And, as long as the requirement is residence, all they have to do is show that they sleep there on occasion, right? They don't have to stay there every night. But if the requirement is domicile, it's a lot harder to prove. And that's the case that we had last year where, we got the St. Charles Parish president elected because of a residency challenge to him. He was living in DC and also living in St. Charles Parish, and it was 11-hour trial on residence. Everything from credit card bills to his auto title to his auto insurance to he had a Christmas card from the White House that had been sent to his home in St. Charles Parish. All of this is evidence that he lived there. And so, it's really fun to try a residency challenge. And, as somebody who only has one house, I mean, I'm just a one house guy, right? But, it's an interesting problem, on a state level. On federal level, it's not an issue because, as you know, Jeff, Congressman Higgins doesn't even live in the congressional district that he represents because the federal laws don't require that same kind of residency.
Yeah, and I guess I want to definitely talk about the fun of these challenges. We'll come back to that a little bit towards the end. But a lot of these issues like residency, are you talking about legal issues or factual issues or a little bit of both? How do these things kind of play out in terms of that determination being made by a court?
What do you think, Jeff? Legal or fact?
I think that I'm going to plug our group again, though. But I think the regional approach that we're trying to implement is really important because it's at the end of the day, this is politics, in my view, both in the courtroom as much as it is for an election. And so having someone who's within your region, I think, is very important. Know your judge. Every case is very different, but I have found that judges are very hesitant to want to stop the democratic process. And so I think that if you're going to go in to challenge someone, you're really pushing uphill. The judges don't want to stop it, and so you need to really be prepared to do that. Every case every case we've challenged, we've been successful because it's always had a really good faith basis, and we've done our homework. So I think it's a tough question to answer, but I think that as long as you get prepared, do your homework, send your requests, you can be successful.
Jeff's right. It's all about the homework. If you don't do your homework, you're probably not going to be successful.
Yeah. Well, this is a topic we could certainly talk about all day. I'll kind of keep things moving a little bit here and just kind of ask, who brings these challenges? How do they work? How does this kind of thing happen?
All of mine have been from candidates challenging other candidates. I haven't had any cases from a citizen off the street yet. It's always been someone, I suppose, who has an interest in the situation. And in my experience, all the candidates are watching each other, and that's how they usually figure out if someone has failed to meet one of the minimal criteria to qualify.
And here in New Orleans, it's a little bit more clandestine. We have citizens that are sometimes connected to the candidate. Sometimes they're not connected to the candidate, and that's why they're the plaintiff. But it doesn't matter what their motivation is, Mike. All they have to do is be a qualified voter. They could do it because they care.
Sure. And it's interesting to hear about the difference between Jeff's practice, where it's always candidates challenging other candidates, and then maybe the practice in New Orleans being a little bit different, where you have really involved citizens who are bringing challenges. And I guess that's that idea of public accountability in office.
And I think that, we have people who want to be the plaintiff as the candidate, right? Because they want, in a smaller community, like say Abbeville, that they want to make sure that everyone knows that they're the one that are bringing this challenge and that they can own this and say, I am the person. But, in a larger city, it's not going to have that same kind of small town feel. And so I think it just depends on the circumstance.
Okay.
There are definitely fewer watch groups in rural Louisiana.
Sure. Understandable. Well, something that I've experienced for the first time when I started working some of these election challenges with Scott is the sort of rocket docket aspect of these cases and just how fast they can go from trial through both levels of appeal all the way to the Louisiana Supreme Court. So if y'all can spend some time, talking about that, what's that experience like? How is it to go that quickly from filing a lawsuit? How long does it take? And just take us through that process.
It's so much fun, isn't it, Jeff?
It's I guess. Yeah, it's definitely exciting. I'll say that. I mean, Scott, I'd be curious to hear, about your preparation. But, like I said, for the most part, I've always had candidates watching other candidates. And so there was always, even if someone hadn't formally qualified and did it on the last day, there was always an understanding or an idea of who may be running against them. And so for the most part, we had our Freedom of Information Act, our public records requests ready or sent out. And so there's only a 7-day window to challenge after qualifying ends. And
Right.
So you have to be ready to pull the trigger within 7 days. And then after you challenge, I think the hearing is within 4 days. It's a really really short time frame. But so I encourage any client I have to do as much legwork as possible to collect data, particularly if it's going to be a residency or a domicile challenge. You really don't have time to issue subpoenas. And so it's got to be as much public records gathering as you can.
Right, right.
At least from what I've seen.
And I mean, we prepare everything ahead of time. You know, we generally know that we're going to have a domicile or a residency challenge ahead of time. And so when we're retained by the client, we go ahead and get ready. We draft the petition, and we go ahead and start drafting the appellate brief too. You know, Jeff said that you've got 7 days to challenge, but that doesn't mean that you have to wait the full 7 days either. You can challenge the day after qualifying ends, and then 4 days after you challenge, you're in front of a judge in a full evidentiary hearing with no discovery.
Sure.
Right? You can do discovery beforehand if you're smart enough to get it served and get the duty judge and all that stuff, and we've done that before. But, you know, and you can take a deposition if you really want to, but to me, these things present the challenge of trying cases like nobody tries cases anymore, with zero discovery and everything just right in front of the judge, just like it looks on TV.
Yeah.
I'll tell you, Scott, the only reason I've not filed any the day after, I've always waited, I've taken advantage of the full 7 days, is because from a tax standpoint is I've always been able to get the Department of Revenue's cooperation to have a witness present in court to give testimony,
Right.
to authenticate their letter or to offer, you know, actual testimony about what's on file. But I've always wanted the extra time to issue a subpoena if I could. And then with respect to, you know, the clerk of court is the agent for service of process for many of the candidates, and the clerk's office, I actually have always included the notice of candidacy qualification forms, because it's essentially an affidavit by the candidate. And so I've always tried to call the clerk of court or their staff as a witness at these trials to confirm what's in the record from a qualification standpoint. And as a courtesy to that office, I've always tried to get their cooperation as opposed to force them there. And so
Yeah.
I have always chosen to take the full amount of time, but that's just been my personal practice.
And I think we have too. I mean, we usually take the 7 days mainly because, you know, the 7 days is usually another Friday, which means that
Yeah.
and then you have Monday and Tuesday, you know, but after you try the case, 24 hours after you try it, you have to get a ruling. 24 hours after that, you have to post your bond and appeal. And then 48 hours after that, you're arguing in front of an en banc panel of the circuit you're in. And sometimes the circuit recuses and you wind up in front of a different circuit because maybe a judge is involved, right? And so, and then, you know, you get a hearing on that. You get a hearing on that, a ruling within 24 hours, and then within another 48 hours, you're in front of the Supreme Court. So you can start from filing your petition to going to the Supreme Court in less than 2 weeks. And, you know, that never happens in a real case. And that's what makes it so fun for us. I feel like it kind of feels a little bit like law school finals. It's just facts.
Yeah, it's really interesting to experience these for the first time. And it kind of feels like the Wild West of lawsuits, where, you know, you can have a client maybe who didn't anticipate a challenge, and then all of a sudden you're through trial and you're through 2 levels of appeal within 3 weeks of meeting the client or being engaged there. So it's just such a really interesting, fast-paced, really fun atmosphere to try cases. So I know it's definitely something that I've enjoyed getting a look at. And Scott, you talked about it a little bit in terms of, you know, preparing appellate briefs before you've even filed the challenge. Can you talk a little bit more about that kind of preparation and things that you can do up front, whether you're the person bringing the challenge or whether you're a person defending a challenge who's running for office?
Yeah, I mean, if you know that your candidate's going to be challenged, you need to start on your defense right away, particularly if it's a residency or a domicile challenge. You're not going to be able to get stuff. You're not going to be able to get stuff like, you know, bank statements or stuff from the DMV just on a whim. It takes time. And so preparing the legal arguments, reading all the cases, I mean, there are only about 110 election law cases total. And I think between Jeff and I, we've read them both twice, right? We've read them all twice. And so, you know, the great thing is that you can really have a mastery in this area of law in just a couple of weeks of work. So, that's why I like to prepare ahead of time.
Okay. And let's talk about when you're actually in that hearing, what are the things that you have to prove for different kinds of challenges? Jeff, you want to take that one?
Sure. I mean, so the tax challenges we've succeeded on, as I said, we called a representative from the Department of Revenue and put him up there to testify that they conducted a search and these were the results of the search. And then we've always taken the position that that satisfies the burden of proof, and it shifts to the candidate to prove otherwise, that they've actually made the filings or they file for extensions. I'll tell you that most of the time when the Department of Revenue gets up there and says they don't have anything, there's nothing. And so the candidate typically has a pretty tough time responding to that. I have not done any, go ahead.
I was going to say, let me interrupt you real quick and ask you, you talked for a second about burden of proof shifting. And I think that that's something that can be lost, but it's such an interesting nuance of this area. Can you explain how that works and what's going on with that here?
Well, Scott, you talk about all those cases we've read. I don't know that I've seen I know the challenger is going to have the burden of proof, but I don't think that you have to prove a negative, obviously. And so,
No, all you have to do is put if you're challenging it, all you have to do is put the objector on the stand, prove that he or she is a voter, and then the burden shifts to the candidate to prove that they're qualified. That's all you have to do. And we've won on directed verdicts before because people forgot to put their objector on the stand and just said, it's time for the candidate to prove the first thing that has to be proved is that somebody's a qualified voter to object. And we won I won the Davenport case before when I was at my old firm, Baldwin Haskell, because the plaintiff just forgot to prove her portion, and that's how we won.
And then in something like a tax filing case, you have to prove that they didn't file their taxes, and then the burden shifts to the candidate to prove that they had an exemption or something like that, right?
Exactly. Yeah, it's a funky burden of proof, and that's why when you ask about facts or law, it's really both. I mean, this is such a strange area of law that it's really both.
Another thing that I was thinking about today as I read over the candidate qualifying form is whether or not, strategically at least, whether or not if you're cross-examining a candidate before they answer any questions, if you should ask the judge to give them a Fifth Amendment instruction, because to the extent anything they said is inaccurate on that statement, which is the whole purpose of the hearing you're there for, there could potentially be criminal ramifications for them doing that. And so if they take the Fifth, that changes the dynamics of a civil hearing, obviously. And so it could just be a pretty good strategy for one of those cases too.
Now, and you bring up criminal, it's interesting. Jeff, have you ever seen a district attorney bring one of these? Because the law does allow the DA to disqualify people.
I have written many letters to district attorneys to bring these, and they don't do it. I have put a bow on a package and personally delivered it saying this is the easiest domiciliary case you'll ever have, and they won't do it. And I'm not saying that they don't want to, because it's a political hurdle. I think that it's a lot of understaffing and budget reasons, and they just don't really have the time to do it within the 7-day period, or they don't feel that they could do it well.
Well, they're focused on the real criminals. Let's be honest.
Yeah. So, but anyway, so that's kind of the IRS the tax challenge. The ethics fines challenge, I take this. I haven't done one on the ethics fines. What I find is that people who typically have the fines pay them the last day or the day that they qualify. It's really unfortunate, but they'll let those fines sit out there throughout their entire throughout the time they're sitting, official, and then they usually pay them the day before. So I haven't challenged one on that basis, but I would probably use a pretty similar approach. Just call someone from the board to confirm that they continue to exist.
It was interesting hearing, the different pieces of evidence that can be used. Obviously, tax return filings for something like a tax challenge. Things like a private investigator, like Jeff was talking about, for residency. I've also heard about water bills, things like Scott's talking about with the Christmas cards. So, interesting that there's different considerations. And And those things, I guess, favor someone who's experienced in doing this area, like you, Scott, or you, Jeff, to, really, if you're running for office or if you're looking for challenges, it really helps to have that experience on someone who knows what they're doing like this. So I just wanted to kind of mention that. And I guess having handled both of these kind of things, is there any kind of favor for the candidate or favor for the person doing the challenge? Which side's favored when these things actually come to court? Can y'all talk about that?
Well, I mean, yeah, the law is very clear that it favors candidacy. And in order to kick somebody off the ballot, you really have to have a clear-cut case that they're violating. And so, every presumption is in favor of the person because, democracy requires that we have the most number of candidates to choose from. And, I've certainly lost election challenges because the judge just said, the tie goes to the runner. And, if it's close, then I have to let the person stay on the ballot. Right, Jeff?
Yeah. And I think if I was a candidate, which I used to want to be one, but that's no longer the case. But if I was a candidate, I think doing your homework is so important. And I think the advice I give all of my clients is just remember that if you want to do this, is that there's going to be ramifications if you lose, right? And so I think that you really need to do your homework and make sure you have a really good case before you try to challenge someone else. Because if you fail, if you can't have them excluded, I think that it could really affect the success of those campaigns. But if I was a candidate, I would take that qualifying form. I would read it carefully. I would make sure I understood everything. I would review it with an attorney, and I would make sure I may even send a records request to the Louisiana Department of Revenue to see what the response is if someone would ask about me, just to know what that answer would be in the event someone did that clandestinely.
Right. It's really interesting that you're going to preemptively request those kinds of records. I think that, little things like that, a lot of this kind of practical advice that I've heard from you and Scott really emphasizes the preparation that goes into one of these, and that's so important for candidates to recognize beforehand, and maybe even have an attorney lined up on their side just in case, because of that quick 4-day turnaround. It really emphasizes to me what kind of preparation is necessary to defend against something like this, and why the benefit of an attorney who's experienced in election law and doing these kinds of challenges is so important for candidates as they prepare to run for office.
Right.
Aside from just the regular guts and grit that it takes to run candidates and campaigns.
That's right.
In the first place.
That's right.
Mike, I'll tell you that any candidate who would try to do this alone, I think would be taking a pretty big risk. As Scott alluded to, the appellate process that follows the trial it all happens so quickly that not having a lawyer to build a proper record and to get all the evidence needed into the record for purposes of appeal, I think that a candidate would be doing themselves a huge disservice if they weren't to have lawyers with them in that process.
That's a great note to end on. Thanks, Jeff. We're going to get that wrapped up now. Yeah. But it's a super fun topic. It's been really interesting to dive in on some of these cases. And this has real life implications for people running for office and for the citizens of our state. So with that, I wanted to thank Scott for joining us, Jeff for joining us from Nooner Pete and Lafayette, and give one more plug for the not only the SNW Weekly Wednesday web chat, but also for the site. Can you give it to us one more time, Scott?
LouisianaElectionLawyer.com, and Jeff and I and Tom and William in Shreveport, we are available to give you a hand. Qualifying is in 7 days, and we're excited about these elections. It's going to be a fun election season, to be sure. All so, right. Everybody, I end every web chat the same way. Wash your hands. Stay safe. We'll see you next week. Thanks, Jeff. Take care, man.
Thanks, Jeff. Thanks, everyone.
Bye, everybody.